Hi, in this presentation we will discuss about patent inventorship and joint inventorship and rights of joint inventors. Patent inventorship. So who is inventor? Person who conceives the concept or idea of invention is an inventor. Person who merely discovers a problem which require only routine solution is not an inventor. As an inventor, one must participate in formation of basic concept of invention. Person who conceives a permanent and definite idea is a true inventor. Inventor may use general information and suggestions of others in conceiving the invention, and that other who is giving this general information and suggestion is not necessarily the inventor in that invention. So inventor is one who conceives the concept or idea of invention. Coming to inventorship and shop rights. An employer or the company owns the employee's invention if employee is party to contract to that effect, and where employee has been hired to invent. Means if employee has signed a contract with the company and he has been hired for inventing, then invention belongs to employer or company. That's why whenever scientists joins in R&D, they all have to sign an agreement with the company that whatever research they will do during employment, all that research and invention and patents on that invention will belong to the company. Company will be owner of all those inventions and patents. So they have to sign that contract during joining of employment, where employee uses time, money, material and facility of employer and conceives or perfects the invention and obtain patent himself on his expenses, then invention will belong to the employee. But employer will have shop right. Means employer may have non-exclusive and non-transferable royalty-free license from the employee. In that case, that is called shop right, because the employee has used the facilities of the employer or company. That's why company will have shop right or non-exclusive, non-transferable royalty-free license in that invention. However, employee has full right to license the invention to others. That's why the license to employer is non-exclusive, and the employee can license his invention to others also. When employer hires a person for general services and employee invents on site, then invention belongs to employee. However, there may be shop right of employer in that invention also. Shop right may apply for employer for non-exclusive license. Now coming to joint inventorship. The joint inventor, they are also called co-inventors. When two or more people collaborate and each contributes to conception of idea about invention, then they are joint inventor or co-inventors. A person who merely follows instruction of another in performing experiments is not co-inventor to subject matter of experiment. He is just helping in the experiment, and he has not helped in the conception of idea of invention. That's why he will not be inventor or co-inventor in that invention. Each co-inventor needs to contribute only to part of invention. Not may not be contribution may not be to whole invention. The contribution may be to only part of invention. Then also they will be called co-inventors. Co-inventors need not make contribution to every claim. If they make contribution only to part of the invention or to some claims, then also they are co-inventors. Two-person totally unaware of each other's work, then there is no joint inventorship or co-inventorship. Two-person, they are working independently in a different lab, not aware of each other's work, then they not be called as co-inventors. No joint inventorship or co-inventorship if each person conceived and reduced the invention to practice during separate non-overlapping period independently. One person has conceived the invention and perfected the invention in a different period in a different lab. Second person has perfected similar invention in different period in another lab. Then they cannot be called co-inventors. They are not co-inventors. They have not participated together. They have not contributed together to the same invention in the same time in the same lab. Inventorship is not improper simply because a large number of inventors are listed. There can be many inventors in a patent, and inventorship cannot be just neglected as or can be called as improper because large number of inventors are there. So whosoever has contributed to the conception of the invention, they will be all inventors in that invention. Authorship does not itself raise the presumption of inventorship. Authorship is totally different from inventorship. Authors in an article may be many, but not necessarily they all are inventors also. Inventor may be one or two person in the authors list. Others who are listed as author, they might have helped in the experiment in the lab. Some of them might have helped in the writing of the article. So all authors are not necessarily the inventors. So authorship and inventorship, they are different. Inventor is one who conceives the invention. Now coming to rights of co-inventors or joint inventors. All co-inventors have equal and undivided rights in invention. Even if one co-inventor has made only small contribution to overall invention, all have equal and undivided rights. Each co-inventor can use, make, sell, offer to sell and license the invention without accounting to other co-inventor, without asking the other co-inventor. Each inventor can use, make, sell, and license the invention independently of other inventors or co-inventor. However, in infringement litigation suit, all co-inventors must join the suit. If one of them refuses to join, then infringement suit cannot proceed. So one co-inventor can create problem for other co-inventor through various means, and one can impede other co-inventors' ability to sue the infringer by refusing to join the infringement suit. So that's all in presentation. Thank you very much.